This is Michael Clara coming to you from the Beehive State. This is part two of Volleyball Mom versus the Alpine Independent School District, or Alpine School District, I should say. This is in reference to, like in part one, we talked about this. This is in reference to an appeal hearing that we'll be doing on Thursday, July 8th. I'm assisting the Volleyball Mom go through the grandma process, and we'll be at the State Records Committee appealing the withholding of records that from the Alpine School District. And then this will be the section 212078 that will be, that's what this video is about. So actually, I'm sorry, that was, let me just clarify that. On the agenda, you see there's two issues there that are under the Alpine School District with this volleyball mom, and this is just the second issue that we'll be addressing. And by way of overview, this has to do with, you can go back and look at part one to get the details of what happened, but this has to do with an issue that happened with the volleyball coach, Dave Neely, back in October 26, 2020. And basically what part one covers is, here's a timeline of what happened at the volleyball game, and then a complaint was filed against him by the athletic director of Tent View High School, and then the process that mom had to go through in order to try to get a copy of the investigation report. And it went back and forth. Is there an investigation report? Is there not? That's what part one is about, and that's what we'll argue before the Records Committee to see if we can get a copy of that investigative report, or the Records Committee will order Alpine School District to disclose it. At the time when this was going on February 6th, when mom filed the grandma notice of appeal with the State Records Committee, it wasn't clear if there was an investigative report. So mom filed a complaint under Title IX, which is a federal act, but there's a local policy that covers it. And I'm sorry, let me say here that what Title IX says by the federal standard, that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program receiving federal financial assistance. And so in the Alpine School District, back in, I think it was, here it is, September 10th, 2020, there was an article that came out in the local newspaper, and it said Alpine School District gives robust update to the sexual harassment policy. And they labeled it Policy 7150. And in this article, Kimberly Bird, who's the executive director of internal relations for operations, makes this big deal about how the board has updated this policy, and that it's going to help to recognize who has what responsibility and what sexual harassment and misconduct is, and that the main goal of the policy that was approved on Tuesday is to ensure that the district is providing a safe and learning work environment for both students and employees. And then she says that the policy offers it's comprehensive. When you look at who do I report to something to, what's an initial response, and she claims that this was going to, that this policy clarified all that. So what ends up happening, mom tests this to some degree, and she files a Title IX complaint against Dave Neely. And he's the volleyball coach. And so on February 6, 2021, the volleyball mom that I'm helping at the hearing, she files this complaint. And when she files it on February 9th, she gets a response from this guy, Jason Feller, and he says, "Hi, my name is Jason Feller. I'm the district compliance officer." And he says, I got your complaint. And then, and he points out to her that that if you choose to submit a formal complaint, I would conduct an initial review. Well, mom submitted a complaint. And this guy says, wants to start monkeying around about informal and formal and things like that. So then, she ends up a month later, not hearing from any of these people. So on March 3rd, she lets him know, by way of clarification, please accept this email then, okay, as my formal submission. All she did is resubmitted what she gave him the month before and said, here it is, okay, if you need me to tell you it's formal, here you go. He tells her the following day that he's, he'll conduct an initial review of what she just sent. That's what he said the month before. So the point is that for a month he's had the complaint, and now when she says, yeah, here it is again, he says he's going to conduct an initial review again. He had a whole month to do it, but anyways. So a couple days later, on March 5th, he tells her he's dismissing her complaint because it doesn't meet the standard for the definition of sexual harassment. And he goes on and he has an attachment and he explains, why he's doing it. And then, some of the significant parts of this is, one of the things I should point out is that once he issues this notice of dismissal, and I'll go into a little more detail about what are some of the issues that we have with it, is that this Dave Neely, who was the subject of the investigation, thanks him and CC's mom on it and says, thank you, Jason, for this update in your documentation. So he basically thanks the Title IX coordinator for dismissing the complaint and never even looking into it. So here's a couple of the issues that mom has with the dismissal notice, is that and this is the very reason why mom filed it under Title IX, because Title IX says that if it doesn't meet the criteria, because let me back up. When the issue happened on October 26th with this coach, mom has no idea what his motives were. What was he, a bigot? Was it sexual harassment? Was it discrimination? Was it just bullying and harassment and had nothing to do with any of the protected classes? We don't know. So mom wisely chose to file under the Title IX because, as this character here points out, he says, also please understand that even though this complaint has been dismissed as a sexual harassment claim, Alpine School District will consider supportive measures. But here's a key part. Investigate the allegations and provide disciplinary action if deemed appropriate under School Policy 5180, which is prohibiting bullying or sexual misconduct, or Policy 70 and 100, prohibiting harassment or discrimination. It's like, yeah, that's exactly why mom filed under this Title IX. So if they didn't believe that it was sexual harassment, then they would have to investigate it under harassment, discrimination, or bullying, which they didn't either. The other thing that was interesting in this dismissal, he says that this dismissal notice has been simultaneously shared with both, which is fine. He says either party can appeal this decision by submitting a written appeal via letter or email to Title IX coordinator, which is him, within 10 days. And so that's just ridiculous, because on the face of it, why would you submit an appeal to the person that already made the decision? And indeed, that's a violation of the policy, and it's a violation of federal regulations. So what mom ends up doing is she doesn't appeal to the decision maker like he told her to. She appeals to Dr. Farnsworth, who's the superintendent, because that's what the policy says. And so she files that appeal on March 12, 2021. And then what happens is when she files it, she explains, in pretty good detail what the issues are, why the coordinator prematurely dismissed her complaint, and why an appeal needs to be considered. So what ends up happening is let me go into a little more detail here. What she says here is that that what Theller tells her, he says, this is what he says in the dismissal complaint, or in the dismissal notice. He says, the information in the two emails paints a picture of an intensely competitive volleyball game. In light of the information provided, it is my determination that this complaint must be dismissed because it does not meet the definition of sexual harassment as described in Policy 7150 and Title IX law. Therefore, an investigation by the Mountain View High School administration into the alleged conduct is the appropriate vehicle to address these allegations, not an investigation under policy 7150. Okay, if that's true, then why not? Where is the investigation then? Why not have them do it? And then Mom points out that Theller's abrupt and perfunctory dismissal of my formal complaint was inappropriate because he never met the burden of gathering one sliver of evidence, which was required. And the policy by the school board, which by the way, here in the state of Utah, school board policy has the force of law within the district. But the problem is that administrators don't follow it, and the board is inept and impotent to even enforce their own policies. Because in this case, the board policy was that the burden of proof and the burden of gathering evidence sufficient to reach a determination regarding responsibility rests on the district and not on the parties. Going back up to what Theller tells the mom is that he just read her 2 emails and it paints a picture. He didn't talk to anybody, didn't look into anything, didn't gather any evidence, and this is what one of the bases of Mom's appeal is to the superintendent. Then what, she says that he doesn't meet the burden, prescribed by the board policy. So then what happens is she points out to the superintendent, Farnsworth, she says, finally, in the notice of dismissal, Theller instructs me to submit an appeal to him. Theller's appeal process is in direct violation of the policy and regulations which require that the decision maker for the appeal is not the same person that made the dismissal determination. Mom even quotes the policy from 7150 in section 10, where it says that either party may, in section, here it goes 10.1.3, that you appeal to the superintendent. And Farnsworth, Superintendent Farnsworth, I think, was a new superintendent. He was an assistant superintendent, and I think at this point he just put in as the superintendent. The man has a PhD. They call him Dr. Farnsworth, but he clearly didn't even read her appeal, which is just astonishing that you have somebody like this running a school district and they don't even read the appeal, because look what he tells her. He replies, I'm writing to acknowledge receipt of your request for an appeal decision by Jason Theller. He will communicate with you to provide clarity regarding the dismissal of the request. And when I read this the first time, I just about fell out of my chair. That's the basis of the appeal, that she goes to the superintendent as the policy states, and he says that the guy that made the decision that she's appealing, that he's going to call her and talk to her about it. This is just ridiculous. So this fool writes, Jason follows through. I wanted to let you know I received your appeal regarding the dismissal. Number one, she didn't send the appeal to him because she's appealing his decision. This is how frustrating and ridiculous this thing is. And if you watch number one, part one of this, consider that this is what Mom is going through and how frustrating this is to be dealing with these incompetent people. The bigger problem is that these incompetents are the ones that are running the largest school district in the state of Utah. And this is why, again, I'm not going to go off on that, why public education is in trouble. But this is a good example, a good illustration of why we're in the mess that we're in. So what Mom does in some frustration then is she files an appeal with the Board of Education. And because, if she files with Farnsworth and he's not going to, he's just going to kick it back to the guy that made the decision. So on March 16th or 13th, we'll have to correct the date on that, Mom files an appeal with the Board of Education. And she says that because Farnsworth's response is not only inadequate, but a violation of board policy and federal regulations. In my appeal to Dr. Farnsworth, I outlined for him why I believe that the Title IX coordinator, Jason Theller, prematurely dismissed my formal complaint in violation of board policy. I went on to explain, and she is very thorough in how she explained what the problem is. She even numbers them for the board and says that, first he exceeded the bounds of his authority, and that he failed to appropriately evaluate the initial notice. Third, his dismissal determination was reached in the absence of speaking to me or my daughter. So can you imagine this? Mom, it takes a time. And when you go back to part one, the principal tells her there's this investigation that's been done, and then nobody actually, she at the time she thinks, well, maybe there isn't one. So let me file a complaint then. And then they won't even accept the complaint, and they dismiss it without even looking into it, without even talking to her. This is how ridiculous this is. You would think that they would at least extend the courtesy to her of a phone call, but nope, they do not. They just keep stonewalling her, and this is their method. They want to wear people out, and typically they do. They go away. The problem is they met this mom, and she's not going away. And finally, mom points out to the board. She says, finally, in the notice of dismissal, Feller instructs me to submit an appeal to him. Feller's appeal process is in direct violation of the policy and regulations which require that the decision maker for the appeal is not the same person that made the dismissal determination. And then she says, I must confess that the persistent instances of misconduct that I have witnessed within the Alpine School District administration is mind-numbing. She says that the plain language, she says it explains there, that she followed the policy and that Dr. Farnsworth did not. And so, she files that. Unfortunately, I put on here waiting for an answer. All I hear are crickets. Amazingly, the board did not, they didn't even extend the courtesy to her to acknowledge that they received her complaint. And they actually didn't even answer it. And let me just make an editorial comment here. Back in the day when I was on the school board in Salt Lake City, this article, front page article came out in the Salt Lake Tribune, and it says, School Board Maverick stirs teacher debate at legislature. And what happened was I went to the legislature to talk about some of the issues that were going on in the school district and why I was alarmed that 52% of the Hispanic students in my district that I represented were high school dropouts. Well, when I did that, the board president in the Salt Lake School District came unglued and told me that I don't have the authority to go over there and talk to anybody. That unless I got approval from the board, I said, that's not true. I'm an elected official. I don't need your permission to go talk to anybody. I represent the people in my community. Well, when I guess, and I do remember, she wrote a letter to the Speaker of the House explaining that I was there speaking without authority. Well, the late Becky Lockhart said he doesn't need your approval. So the Speaker actually asked them to come to the next committee meeting for the legislature, and there was an education task force that was formed at the time, and they told the legislature, yeah, Michael Clara was here without authority, and legislators told him he doesn't need your authority. He's an elected official. And then they quoted the law that said that a local school board of a school district is a body corporate. And what they explained was, and this is what they had been telling people for years, is that a board member, that when you're on the school board, you only have authority when the board is in session. And once that board is not in session, you have no more authority. You're just a normal citizen. Well, when I was taught that, when I got elected, I said, absolutely not. That is wrong. That is, I said, you would never say that to the governor. You would never, he's not in a legislative body, but you would never say that to the legislature. You would never say it to a city council member. So why would you say that? Why would that apply to a school board member? So what Speaker Lockhart did in her wisdom, and I believe it was actually Representative Gibson who's in this area of Alpine, he sponsored a bill and added this number 5 to the law. So these knuckleheads up at the school board association and the leadership in my school district, which is the capital city, would understand that now number 5 was added to the law that says, notwithstanding a local school board's status as a body corporate, an elected member of a local school board serves and represents the residents of the local school board member's district. And that service and representation may not be restricted or impaired by the local school board member's membership on or obligation to the local school board. So the late Becky Lockhart, speaker at the time, she was wise to put that into the law. But the problem is you have a board like Alpine who will ignore. Each of them got a copy of the complaint of the appeal that's their own policy that says that you can appeal it to them, and they ignored it. So hopefully, somebody can send this video to them. They can look up the law and recognize they don't need to listen to the superintendent, Farnsworth, or the incompetent attorney, Patrick Tanner, that says don't say anything to anybody. No, you represent the people. That's the law. Don't let the very people that work for you, the board is letting them tell them how to do what to do. And they're the ones that are supposed to be giving oversight to this governmental institution. And instead, they act like they work for the very people that actually work for them. So what happens here is that mom ends up, after filing that appeal to the board, she submits a grammar request or a records request. And this is separate from the records request that she did in part one, because we're in part two. This is a second records request. She says, well, let's look at Theller's emails. Let's look and see what it is that they talked about that led him to this decision. She ends up getting I think a little over 100 pages, and they charge her I think $200. We'd have to see the amount. And really only 10 of the pages were actually new documentation. The others were stuff that she had sent in. But one of the emails that's interesting that she got in this records release was an email dated March 18th, 2021, and it's from Dave Neely, who is the one. And so after Theller informs mom that he's not going to accept her sexual harassment complaint, Dave Neely, who was a subject of that complaint, sends this to the Title IX coordinator and says, thank you. There's one piece of additional information I would like if possible. So what we know now is by that first sentence is that Theller has sent Dave Neely information on what mom's complaint was about. And who knows what other information about mom that Theller, the Title IX coordinator, sent to Neely, who was the subject of the complaint. But this is astonishing that Neely is asking Theller in this email that he wants to know what mom wrote in the formal complaint, and if so, I would like to know what her answer was to the form's final question. What would you like to see happen? And then he goes on to say, and I don't know, they blocked something out here, which we'll have to ask a records committee to compel them to disclose it. But he goes on to say, I am currently preparing to file for a stalking protective order and am compiling as much evidence as possible of her and her family and her friends participating in acts of stalking against me. Her answer to that question is one I would like to include in my documentation. If she continues to pursue this, I will also file a civil suit against them for libel, harassment, defamation, stalking, threatening violence, etc., etc., etc. She's clearly not going to stop on her own accord. So anyways, that to me rises to the level of retaliation because mom, so she files this complaint and he's going to take her to court over it. This is how ignorant these people are. So the board never replies to mom. Dr. Farnsworth, who says he's not going to reply and sent her back to Theller, now decides he's going to reply. And basically what he tells her is that, that Theller did not violate the proper procedure by informing you that your appeal of dismissal decision was to be submitted to him. Delivery of your appeal to him does not mean that he is the decision maker, merely that he would then transmit that appeal to me for consideration. He has not purported to consider or render a decision on your appeal. In any event, you did not submit your appeal to Theller, but submitted it directly to me as provided by the current policy. So I'm not even going to waste your time and mine by going back and reading what he wrote already, because you can remember what he said. He's I don't know, maybe he shouldn't be the superintendent if this is how ignorant he is. He can't even keep up with his own words. I don't know if that's because he's lying and he can't keep up with his own lies, or I don't know. Maybe he just can't comprehend, but it's scary. It says he has a PhD and he's the new superintendent, and somebody needs to tell the board, you got an incompetent man running the district, because he really, every time he writes something, all he's doing is highlighting his own incompetence, and that's scary. Maybe they need to bring this up in his evaluation. How anyways, I'm not going to keep criticizing the man. He speaks for himself. So mom goes through the process, and I'm not going to spend a lot of time. I'm not going to spend any time on it, but they give her some records, only, like I said, about 10 pages, and then they charge her close to $200 for nothing. And that's one of the things we're asking the records committee to dismiss, is the amount of money, because it's unreasonable. And we're going to ask the records committee to compel the district to release the remainder records that they're trying not to disclose. Now, this incompetent attorney that the district has, and we should look up and see how much they pay him, because this is a waste of money, of taxpayer dollars, because this guy is just as ridiculous as the superintendent. But here he writes a letter, because he's required to write a letter to the state records committee. And basically what he's telling the state records committee is that Thaler conducted the initial review as required by the sexual harassment policy, which this is something that they're not even going to look at. But for whatever reason, he's explaining this to the state records committee, which this is not even in their purview, but he's explaining this. But it does point out that he's saying that according to the policy and according to federal law, however, Mr. Thaler also explained that the district was willing to consider supportive measures to investigate and proceed under policy 5180, which relates to bullying. And again, remember our policy 7100. And if you recall, this is what mom points out to them. Well, actually, Thaler does too. He says, yeah, it's not sexual harassment, but we could look at it under these two. Well, you know what? Thaler is responsible for ensuring that the district does that. They haven't done it. They didn't do it before. They didn't do it after. And this is what part of the thing that, even though it's not in the purview of the records committee, it does reveal that they're not following the school board policy or federal law. This incompetent goes on to explain that mom makes two arguments, and he's telling the records committee a substantial portion of the appeal is devoted to presenting arguments regarding the merits of her complaints about the October 27th incident, the district's handling of her complaints about that incident, and the district's handling of her Title IX sexual harassment complaint relating to the incident. Her arguments regarding the merits of these matters are one-sided, incomplete, and speculative. So if I wasn't on video, I would say no blank, Sherlock, because, this thing here, he's saying that maybe they are. If they are one-sided, incomplete, and speculative, that's because the district won't give her any information. She's been having to fight them the last 6 months and try to piece together what's going on. And then they're going to turn around and accuse her of being one-sided, incomplete, and speculative. Well, if that's the case, you can solve this by not withholding information and talking to her. They don't even talk to her when she filed the complaint, much less talk to her now. So it may be. At the end of the day, we might find out that it is, but you know what? That's not her fault. These are conditions that these idiots have created up at the district. And then he says, however, none of these questions or issues is properly before the state records committee. That's true. While the district denies her complaints about these matters that they have any merit, it objects to her effort to address and revisit these complaints in this forum, which is neither intended for such purposes nor would it afford due process to the district. Wow. So what's ironic about this is that they're the ones not giving her due process. They won't even investigate her allegations. And then, according to the policy 7150, and it's patterned after federal law, they have an obligation then to investigate it under 2 other policies that they've quoted, but they have not done it. And then this idiot is going to turn around and say, act like they're the victims in this. This is just how blind these people are, because they lie so much. You know, they lie so much that whenever they tell the truth, I'm surprised. That's how much these people lie. So this is what we're dealing with. And all this tomorrow, today's Wednesday, so this is happening Thursday, July 8th, 9 a.m. In this video, I'm not bringing up any of the arguments that we're going to present on this second issue, but show up tomorrow. You can see it online also, and we'll see you there and see how much of these deceptions and lies we can get disclosed, and that the Records Committee will order them to give us the information they're withholding. See you tomorrow.